Hello everyone, I'm Professor Paul Carrier, and what I'd like to do now is talk to you about the contract's issue of integration. Integration is actually a subset of interpretation, and the idea is that, or the purpose is to determine when parties are discussing and negotiating, there's this preliminary negotiations phase. A lot is said, emails are passed, phone calls are made, statements are made, and the question becomes, if there's a final contract, oral or written, do the things that were spoken about beforehand go into the contract or not, where the contract itself doesn't include those terms? Sometimes the agreement, oral or written, is intended to be the final. In other words, anything not in here is not part of our deal. It was part of what we discussed in the past, and we negotiated them. We got rid of all those other discussions or problems, and this is the final, again, oral or written. Sometimes parties are a little more flexible. We need to get this done quickly. Look at my prior email, and that's the date. Delivery dates are in my prior email. Don't worry, get the contract to me. Prior email says the delivery dates I need. So that would be that prior email would be the kind of thing that you ask whether or not it goes into the final version. It is a question of interpretation. You're asking yourself, when you're looking at the final manifestation of agreement, does it include prior or contemporaneous materials that are not in this final version, again, oral or written? So you're interpreting whether or not the contract was intended to be complete or whether it was intended to allow supplementation or explanation from things prior. Okay, so it is a subset of integration. Let me try and put it to you this way. And I would mention that many case books approach it from the opposite way. Case books often start with the integration question, all right, even though it is a subset of interpretation. The integration question is determining what is in the final agreement and what is not. The interpretation question, which we covered basically 2 sessions ago, is once you have the final agreement, you ask whether or not something within it is ambiguous. And if so, how does a court go about interpreting? Okay? So, the purpose again is, did the parties intend for the final manifestation of their agreement to be complete? Or is it supposed to be, or is it allowed to be supplemented with terms and or conditions from a prior or contemporaneous discussions? Okay? What are prior or contemporaneous discussions or terms? Well, they could be prior emails. They could be prior statements. They could be prior faxes. They could be brochures from the past. They could even be prior samples. And the question becomes, if those elements, those ideas, those parameters do not show up in the final agreement, did the parties leave enough wiggle room for those to actually be brought back in, the prior and contemporaneous kind? Okay? The idea of timing is important, and this is a small distinction, but it might be the difference between getting a multiple choice question right or wrong. Timing for parole evidence, or for this integration question, is prior or contemporaneous. We are not looking at things done after the agreement is in place. All right, and I'll explain that in just a minute. So again, you're looking at prior or contemporaneous statements that don't show up in the final manifestation, oral or written, and you're asking whether or not those actually still can come in to supplement the terms of the parties' agreement. Okay? You do not allow those in. Prior or contemporaneous statements, brochures, samples, emails, those do not come in under the following conditions. First, if they are contradictory. If there's something in the agreement and there's a prior or contemporaneous email that pretty clearly contradicts what is in a term. This says by Friday. That says by Sunday. The prior says by Sunday. You're not allowed to bring in things that would contradict. Okay? If the date Friday was unclear, if it were truly ambiguous, you could possibly use the prior email to interpret what that is. But if it's clear, you don't bring in evidence of prior or contemporaneous terms that are contradictory. Further, not if the term you're looking at, the idea, the parameter is subsequent. This question of integration and its parole evidence rule, which states, by the way, you're not allowed to allow contradictory evidence from a prior or contemporaneous source into a fully integrated agreement. If it's not fully integrated, those may come in, prior or contemporaneous. You could have a contract that's partially integrated. And so prior or contemporaneous terms or conditions cannot go in to that part that's fully integrated. But if you have another part of that agreement that is not fully integrated, then you might allow prior or contemporaneous terms in as terms of the contract, not subsequents. So if you see an after formation modification, that would not implicate issues of integration and its parole evidence rule. Preconditions to formation are also not, the parole evidence rule does not bar evidence of those to prove what the parties intended. And I think an example is particularly appropriate here. Let's say that I'm speaking with you and I say, if I get a new job next week, I will buy your guitar for $500. But I write down, I will buy your guitar for $500. I fail to write, if I get a job next week. Well, getting the job so I have money to pay you is a precondition we probably both know about. You may bring that I have to buy your guitar for $500 to me, you may sue me, but I will always be allowed to bring up the parole evidence of our agreement of the condition. Wait, remember what I said. I will only be able to do so if I get a new job next week so that I can pay you. That parole evidence rule never bars evidence where you're trying to prove whether or not there's in fact been formation. If you've got formation and then you're trying to look what is in and what is not in, you use the integration / parole evidence rules. If you're looking at whether or not the formation has occurred, okay, including, for example, a precondition to formation, then you do not apply the parole evidence rule. Another good example, defenses to formation. If somebody is insane, if somebody is committing fraud, if somebody is exercising direct problem with formation. It's a defense to enforcement. So it may be, we might say that the contract was formed, but we would say that we still have a defense to the enforcement of same. And the parole evidence rule never bars evidence to try and prove that there has been some kind of fraud, some kind of duress, or some kind of other factual situation that would allow one of the parties to successfully assert a defense to enforcement. Okay, so when you're looking at problems with formation, okay, whether it's a precondition or maybe a defense that mucks up, prevents formation, or at least if there is formation, nevertheless allows a defense to enforcement, you do not use the parole evidence rule. Okay? Special considerations. When you are trying to determine whether or not this contract or this agreement you're looking at is fully integrated, you want to look for a merger clause, also called an integration clause, also sometimes called an entire agreement clause. Whether it's oral or in writing, if the agreement includes this is the full and final manifestation of the parties' agreement, that's your merger clause. We'll just call it a merger clause for the rest of this presentation. The merger clause gives you the sense that you're not allowed to bring in anything prior that was stated prior to or contemporaneous with formation. I want you to understand that that is not dispositive. It is highly relevant. It is highly trustworthy. It's very good evidence of the party's intent to have a fully integrated agreement that does not allow prior or contemporaneous evidence. But it is not dispositive. And so someone can still try to say, well, we had a merger clause, but on this particular issue, we really didn't mean it to apply to that. Okay, so it's great evidence. Very likely that the merger clause is going to lead to your interpretation that a contract is fully integrated, but you can't say it as a slam dunk. You still have to go through the analysis of whether or not you believe it to be fully integrated, even when there is a merger clause. Okay, by the way, if you see a merger clause, courts, since we're still in the area of interpretation, would probably go right to the plain meaning rule. There's a merger clause, its meaning is plain. We don't see any reason other than to say that it's fully integrated and it prohibits the introduction of evidence of anything prior or contemporaneous to our actual formation. Okay? Another question you need to ask, and this is a second way of bringing in prior or contemporaneous evidence into parties' agreements, and that is the doctrine of collateral agreement. There are certain situations where parties intend for there to be separate agreements. Here's the agreement. Let me give an example. It might be easiest. Here's an agreement where you're buying my company. You're going to basically terminate half of the employees and replace them with your own, since you're taking over our company and merging it into your existing company. You want to keep me because I am a key employee. So here's the agreement where I sell the company shares to you, and you do what you need to do to merge it with your company. The separate key employee agreement would be for me, and you might need to pay me oodles and oodles of money to stay on for 2 or 3 years to make sure the transition runs smoothly. Do I want everyone to see how much you're paying me? And the answer is no. And so there may be a logical reason why we have the share purchase or company purchase, right? The participation purchase shares, and the separate employee agreement. Now, were they done together in part of one deal? Yes. Do we have a reason that they are put in separate agreements? Yes. And if that's the case, we can argue, wait, we didn't include the key employee payment to this particular party in the share purchase or in the participation purchase. By the way, if you noted, I say share versus participation. That's the difference between a joint stock company and your basic LLC, which has participations and not shares. Okay? There's a difference because we don't want that to be listed in places that other people will be able to see it, because I want to hide how much you're going to be paying me. There's a reason why we have it in a separate document. That's the collateral agreement doctrine. So if someone tries to argue that's the full and final agreement, we don't have an agreement with you as a key employee, you're lying, I could say, wait a second, we intended for it to be a separate agreement. It was part of the same negotiations, and there's a reason why we did not include it in the final. Okay, so that's the collateral agreement doctrine. Florida law recognizes both the parole evidence rule, merger clauses idea, and the way to get around it, as well as the collateral agreement in such cases. In fact, it's again an interpretation issue. Is that the kind of thing that might have been done by the parties with a backroom handshake, which explains why it was not included in a particular agreement that's now being argued as fully integrated?